Welcome to Law, Life, and Liberty with Anthony Puopolo.
Welcome to Law, Life, and Liberty with Anthony Puopolo. Anthony G. Puopolo is a Massachusetts attorney who helps families navigate divorce, custody disputes, and criminal charges that often overlap. With offices in Lowell and North Andover, he's represented clients across Middlesex, Essex, and Suffolk counties in both family and criminal courts. I'm Lisa Mosby, your host, and today we're talking about what happens at a Massachusetts 209A restraining order hearing. Welcome, Tony. Thanks so much for being with me.
Thanks for having me.
Tony, when someone is served with a 209A restraining order in Massachusetts, what typically happens between the initial emergency order and the first court hearing?
Well, as far as courts are concerned, nothing's really going on with the case in court, but you should be preparing for that hearing very diligently. You should be looking for an attorney with experience in restraining orders, and you should be examining the affidavit that was filed with the restraining order. The police are generally not going to serve that on you with the order, so you will likely need to go to court to get that affidavit. They will generally tell you they won't give it to you until the day of the hearing. They'll give it to a lawyer, though, which is another reason it is very important to get a lawyer as soon as possible after you're served to give you as much time to prepare as humanly possible. If you were arrested and the order is issued that day while you're being arraigned, do not let them have the hearing, because some judges will say, everyone's here, let's just have the hearing. You need to say, no, I need to hire a lawyer to be prepared. So definitely do not do the restraining order hearing at the arraignment. You're going to need to gather all the possible evidence that you have on the allegations that this person is making, whether that be text messages or videos, things like that. It's critical that you spend the time between the emergency hearing and the full hearing preparing to defend that case.
And then when people walk into a 209A hearing for the first time, what usually surprises them about how that process actually works?
Usually, in my experience, people are most surprised with just how much can come in. People are surprised when they hear, well, that argument happened 4 years ago. Why is that being brought up now? Because a history of abuse is relevant in whether or not there's a current risk of harm. So people are generally surprised by the scope of what happens in a 209A. People are not limited to what they put in the affidavit as far as allegations are concerned. They can bring in, for lack of a better term, the kitchen sink if it will help the judge make a decision.
And then, Tony, at that hearing, what does the judge need to see or hear in order to extend the restraining order beyond the temporary stage?
So the standard for a judge on a 209A is whether one or more incidents occurred which creates a substantial likelihood of imminent risk of serious bodily harm. So the judge needs to find that there is a current risk and that it's either going to be bodily harm or abuse under the statute. Now that can be with some changes that happened in the law a few years ago. That can be what we call coercive control. That's evidence of financial abuse, withholding funds from the other partner, trying to isolate the partner from friends and family, threatening the other partner, threatening to harm. I've seen one where there was a threat to harm the pet of the other partner. Those will all be things that the court will determine whether or not constitutes an imminent risk of bodily harm or abuse.
And then from a defense perspective, what are some of the biggest mistakes people make before or during that 209A hearing?
Well, I once watched a litigant who was representing themselves try to introduce an illegal audio recording. They had wiretapped their significant other during the incident, and that is a felony. So that is one of the more common mistakes is people also just try to argue, well, I hit her because she hit me first. This is her restraining order. not yours. So you've also now just admitted to something that can charge you criminally. So realistically, going in there just prepared to defend the allegations and not sling mud is one of the best ways to try to handle a restraining order hearing.
And then how much evidence usually comes into play at these hearings? Are we talking about testimony only, or do things like texts, emails, photos often become part of these cases?
I would say texts are actually some of the most common testimony I see in restraining order hearings. Emails less so, because the major difference between a text and an email is the amount of time it takes to send them. Usually you're able to calm down a little bit between, if you're sending a text, it's rapid fire back and forth. You're angry. Language is terrible. Sending an email, you got to sit down, open up your laptop, turn it on, wait for your email to pop up. By the time that happens, you've calmed down a little. So emails I tend to find a little less common. Video recordings, because as long as the other side knows they're being recorded, it can come in. It's not an illegal recording. I've absolutely seen audio and video recordings in restraining order hearings as well.
I'm kind of curious. This is a side note, but are video recordings illegal only if the other person is talking, or can you do a video recording observing behavior and that is not illegal?
Wiretapping covers audio recordings. So if you're video
Okay.
recorded, as long as there's no audio, it doesn't fit within the wiretapping statute.
Very good. Thank you for that. If the two people involved are also going through a divorce or a custody dispute, how does the restraining order hearing affect what's happening in the family court system?
Well, if it's a divorce that doesn't have children, it'll have minimal impact. Realistically, it will just likely result, if you're not already out of the marital home, you will be now. If there are children involved, if it's a divorce with children or a child custody dispute, it will have substantial impact. If the children are on the restraining order, you will not be able to have any contact with the children absent a modification issued by a family court judge. If the children are not on the restraining order and are old enough to be able to communicate or meet with you on their own, then you'll still have the ability to meet with or talk to your children. But it will be very important to make sure that you absolutely do not talk to the children about the other parent who has the restraining order. Because if it's a message that is reasonably calculated to get to the other person, it's a restraining order violation, which is a crime. So it does have absolutely substantial impacts on those proceedings. It can essentially completely wipe out your parenting time until a judge modifies it.
If the judge decides to extend the restraining order, what does that usually mean for the person it's issued against in terms of daily life and contact with the other party? Let's be more specific so people have a clear understanding.
Sure. So two different questions. Really, as far as contact with the other party, it's substantially altered. There is no contact. That's essentially what a restraining order is. Stay away, no contact. So it will completely sever. I tell my clients, if they lose a restraining order, the best way to think about that person is they just died today. Don't talk about them. Don't consider calling them because they're not around anymore. If there are children involved, that absolutely, obviously, substantially alters your daily life. But as far as, if it's just a relationship that went south, obviously contact with the other person is substantially altered. But as long as you comply with that order, your daily life is likely to not be all that materially impacted. If it winds up in criminal matters, like if there is also a domestic violence allegation that results in criminal charges, I've seen people lose their jobs over them. So it really depends on how far these allegations go.
And then on the other hand, if the order is not extended, does the case just simply end there, or can the situation still affect future family or criminal matters?
So essentially it just ends there. I've seen people try to advance the arguments in family court that they lost the restraining order on, and it doesn't go well for the family court judge, to be honest, because the district court judges and the family court judges, it's the same standard of proof, what we call preponderance of the evidence, which is essentially, if I had to put it in mathematical terms, you win on preponderance of the evidence if you get slightly more than 50% of the evidence. Realistically, if you lost a restraining order on these allegations, a family court judge is going to look at you and say, you already tried this, and another judge didn't believe you. So what has changed that makes you think that I'm going to believe you now? So realistically, if you've lost the restraining order, it doesn't serve your interest to try to continue to present that narrative.
Makes sense. Tony, let's wrap this up for our audience. For someone preparing to walk into a 209A hearing in Massachusetts, what is the most important thing that they should understand about how these hearings are decided? And any final thoughts or guidance that you have, let's share it with those folks.
Well, as I mentioned, it's a preponderance of the evidence standard, which is just slightly more than 50%. You need to take these hearings incredibly seriously because it is a civil order, but violation of that order is criminal. And if you think this is the type of person who's going to try to come after you criminally, you absolutely need to do everything you can to be prepared for that hearing to defend yourself. And I don't recommend at all that people do it on their own. You need a qualified professional who does this for a living and understands how to present these cases. Everyone thinks I can sit down and write everything out, and ChatGPT is the biggest thing now. Everyone thinks they can present their defense in ChatGPT, and maybe you can. But getting up in front of a judge is an art form. It really is. It is terrifying. My associates, when they start, they don't realize just how nerve-wracking it is just being in that room with everyone staring at you, the judge staring at you, the audience staring at you, and even some of the most well-laid plans for that presentation go out the window when there's 50 people looking at you talking about the private details of your relationship. So the most important thing in the world, get a lawyer, someone who will represent you, who is distanced from the emotions. So often I see people in these hearings who represent themselves, they get caught up in their anger and they don't present themselves well because they're angry. They want to lash out at the other side. And that's not defending you. That's, in fact, indicting you. It's making you look like the person that this person is claiming you are, even if you're not.
Well said. Thank you so much, Tony. Great insights today, and you shed a lot of light on this whole process. And we are not geared up or ready to handle it as lay people. So thank you. Really, truly, thank you for your insights. Folks, that's it for today's episode of Law, Life, and Liberty with Anthony Puopolo. To learn more about Anthony and his work across Massachusetts family and criminal courts, please visit agplawoffices.com. Thank you so much for listening, and don't forget to subscribe, leave a review, and please share this episode if you know someone who might need it today. We'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.